starting at the Supreme Court. And in fact, speaking of the original Renaissance man, the guy who is our associate producer, makes all of the wonderful sounds and things happen on our program, is one of my favorite, bouncing topics off having to do with the law, a law school graduate. Shane Farnan is with us. He's also the Supreme Court reporter for the Talk Radio News Service.
Yes, I am.
And credentialed, and you're there, and so you were there this morning.
Very heated.
Yeah. Now, so the case that we're talking about here is the Voting Rights Act.
Exactly.
The Voting Rights Act of 1965.
The Voting Rights Act of 1965, which has been reauthorized a few times by Congress through the years, most recently in 2006. Shelby County, Alabama, has sued, saying that it's unconstitutional. So the court took that up again. They took it up most recently in 2009, but again today.
Right. And the basis of the argument that Shelby County is making?
The basis of their argument is that things are different now. The South has changed, that it's no longer necessary to treat certain states differently than the other states, and that the Voting Rights Act, at least Section 5, is no longer necessary in that Section 5 is a little different than the rest of the Act. Section 5 says certain states, because you've had such a long history of discrimination, if you're going to change your voting rules, you need to get clearance from us, the federal government.
Right.
And a lot of the states don't like this, so Shelby County sued to have this stopped.
Right. And the argument that is being made, at least that I've heard on Right Wing Talk Radio, is, hey, you've got districts that are all black. You've got elected officials who are African Americans. You've got voting officials who are African Americans. You've got judges who are African Americans. How can you say that there's still discrimination going on in these areas?
Well, Congress did a very in-depth review of this, and that's what Congress's job is. Right. And a lot of the argument before the court went this way. And really, there was an argument before the court, but there's also, it seemed, an argument among the members of the court. Right. Essentially saying, this is Congress's job. This is not the Supreme Court's job.
Right. So
and they went through thousands and thousands of pages of documents and dozens of witnesses and hours of testimony.
Congress did
in order to reauthorize this
in
act
2006.
In 2006. And
so, in other words, the conservative talk show or Fox News talking points are nonsense. I mean, yeah, there may be areas where you've got a lot of African American voters and you've got African American elected officials. Mm-hmm. That doesn't mean that there is not racism that is playing itself out in the polls.
And we saw that in the last election specifically. And we even
long voting lines in black areas.
Voting lines. There was a head of the president of the GOP down in Florida who admitted that some of their rules that they were trying to enact were specifically to disenfranchise black voters down in Florida.
This was their strategy. Yeah. So I'm curious what standing Shelby County claims they actually. Before we get to that,
sure.
Justice Scalia made some interesting comments today.
Interesting.
So what did he say?
Well, he kept asking. He asked about 3 times before he got to his actual point. He was talking about the reauthorization and the vote tallies on the reauthorization in the Senate. He said, the first time it went through, there was a dozen or so who voted against it, and then 9. I don't remember all the numbers. But he said this most recent time when the Senate voted on the Voting Rights Act to reauthorize it, it was 98-0 in the Senate. Mm-hmm. And he was rhetorically asked. The question was kind of like, well, does that mean that the voting rights is more necessary than ever? Or is discrimination worse than ever? That now 98-0, the Senate believes that this should be reauthorized. And then he went on. Now, let me see if I want to find this exactly. He went on to argue that the act itself is this is his quote, a perpetuation of racial entitlement. And I think this is the line of the argument. And you'll see it a lot in the headlines and the blogs. He said that the VRA, even though it was voted 98-0, this was evidence that Congress will never vote to not reauthorize. In other words, get rid of the Voting Rights Act. Even if it became unnecessary, or if it's unnecessary now, politically they don't have the fortitude to say no to it because it's a really cool-sounding act.
Right. So the essence of Scalia's argument, mm-hmm. It's not really an argument, but of his comment seems to be that he's saying that Congress won't do the right thing mm-hmm. by doing away with this because, if you vote against the Voting Rights Act, African Americans won't vote for you, and even Republicans need African American votes. And so Congress can't do the right thing by doing away with this. So it's our job.
It's our job because Congress doesn't have the political will. There's this,
And where in the Constitution does it say it's the job of the Supreme Court to fix legislation that Congress doesn't have the courage or integrity or intelligence, which would be the position Scalia is taking? I disagree with him, but let's just assume that there's something to what he's saying. Where in the Constitution does it say that it's the job of the court to fix bad legislation?
I can't find it.
Yeah, it doesn't exist.
They can review cases that have come up, and they can find a law doesn't line up with the Constitution. That's, of course, where Marbury versus Madison came from. But to take a case, essentially Shelby County said, we don't like this law. We're going to sue over it. We want a declaratory judgment saying it's unconstitutional. They're not even bringing up a set of facts other than, you guys have used this against us before and you're going to use it again, so let's have a ruling on this. And so that invited the court to look at every state.
So wait a second. Let me get this straight. Yesterday, Scalia said to the ACLU and the Center for Constitutional Rights, you guys cannot issue a subpoena to the National Security Agency for wiretaps against you because you can't prove that there are wiretaps against you,
right? Because
the National Security Agency won't tell you if they've wiretapped you.
Because it was too speculative.
Right. And in other words, you don't have standing to stand before this court because you don't actually have a case. You can't demonstrate that you've been harmed.
Right.
So they threw it out.
Right.
And thus we have no right to find out if we're being wiretapped or our emails being read by the NSA or CIA or FBI or the local sheriff's office. But at the same time, Shelby County, Alabama comes in and says, we got no case, we got no complaint, we got nothing to point to. And the Supreme Court says, fine, come on in.
Well, arguably, you could say that they actually have had this many, many times. In fact, Sotomayor called Shelby County the epitome of why this law was enacted. So over the years, the Voting Rights Act, they have had pre-clearance voting changes that were struck down by the pre-clearance process. So it has been used against them in the past.
But they're not arguing those things.
No, they wanted a giant argument about the overarching issue of it, the constitutionality.
But how do they establish standing?
By saying that before they've been the subject of this, and they probably will be in the future. That's how.
But you could say...
Which is the same argument that they probably made in front of FISA.
The ACLU could have said the same thing about FISA.
They couldn't prove that they had before, but they said they're likely to in the future. So
we're splitting hairs here.
We are, and the Supreme Court just wanted to hear one and not the other.
Yeah, and I don't think the Supreme Court should,
right,
frankly, even has this power. Much less. This is insane. This is absolutely insane. Justice Thomas, I'm guessing, the only African American on the court, didn't say a word. He
didn't say a word.
Does not.
No.
Anybody else say anything of interest? You were commenting about Roberts before.
Roberts, pretty much, he asked point blank of, is it the government's submission that citizens of the South are more racist than citizens of the North? Which I thought wasn't really a relevant inquiry. We were talking about institutional racism here, not citizenry.
Well, I mean, you could argue that the citizens of the South tried to separate from the Union over the issue of slavery.
What he's saying currently.
Yeah.
And no one's going to go in front of the court and say, yeah, everyone in the South is racist, especially the Solicitor General of the United States.
Right. But arguably, wouldn't that, I mean, is it not inconceivable? I suppose it wouldn't be coming from Roberts. It would probably be coming from somebody like Ruth Bader Ginsburg, who would say, we are finding that Section 5 of the Voting Rights Act is not constitutional because it doesn't comport with the Equal Protection Clause of the Constitution. And what you have to do to make that comport with the Equal Protection Clause is apply it to all the states.
Yeah, that's a different
question.
There's
plenty of racism going on up in Wisconsin.
After the break, because the Equal Protection Clause applies to people.
Yeah, okay. So we'll pick this up after the break. Thanks a lot, Shane.
Thank you.
It's amazing. And it's what's really going to be amazing is to see how the Supreme Court rules on this when the time for the